We are on section 9 in remedies, and we have to talk about discovery a little bit. And I was thinking just before I came up that I could tell you and go through the usual lecture on discovery and how each one works and the like. Or if you have questions on it, I could answer your questions instead. By questions, I mean, how does it actually work? What's the process generally? Where are the hurdles? If you have, I mean, you've heard the standard lecture on discovery before from me about interrogatories, production, and all the rest. So I expect that you understand what each one entails. Do you understand how it works in practice? Because that's the idea about this course, is to take theory and blend it to a much greater extent with respect to practical knowledge. Go ahead.
So you deal with admissions first in practice?
No, actually, I almost always deal with admissions pretty close to the end.
Okay.
Well, okay, let's talk as a practical matter. First of all, there is a difference now between the scope of discovery in federal court and in state court. Federal court has cut their scope of discovery back, and the new language and the word that is the guiding principle behind it is that the discovery must be proportional to the case. And so it's not only are you entitled to get relevant evidence, but you may not even be able to get all relevant evidence in a civil case in federal court if your requests are not proportional to the case. Now, proportional, they say, to the needs of the case, to the financial resources of the parties, to the value of the case, to the importance of the case. And what concerns me about language like that, when we talk about proportional to the value of the case and the needs and the financial wherewithal of the parties and all the rest of it, and the importance of the case issues, every case to every plaintiff is vitally important. You know, the federal court might not see some poor guy who was injured on the job severely as being that important of a case on a policy basis, but to that individual, it may be the difference between I don't want to say life and death, but a decent life, as opposed to not being able to pay your bills and worried about where your children are going to sleep at night and all the rest. And so I worry that the new language, proportional, potentially could favor large companies who tend to want to fight tooth and nail about everything, find an ally in the federal court, and use discovery or use the new rules to prevent discovery on necessary information to prove your case. So I'm just trying to point out the new rules have a difference between what historically has been the case with discovery, which is that, you know, virtually anything goes that isn't otherwise privileged, that is going to help prove or disprove a fact or consequence to the case. Well, now the language gives the judge a lot more power to restrict parties' access to information. Defendants are always going to complain that you're asking for too much information, it's too time-consuming, too expensive, and the case isn't worth this type of what they would call a fishing expedition. That's always the battle cry as they oppose turning over information that the other side wants. And I worry that the new rule gives them more latitude. So the point of all of this is, you know, a lot of times we have choices about federal court or state court when we talk about subject matter jurisdiction, personal and venue, and the rest. Well, that's another consideration now. Maybe I should go to state court because I'm likely going to have the benefit of more generous rules with respect to discovery. And that's a legitimate question that you should be raising, because the scope of discovery in federal court has narrowed. Now, once we get past that, matters that are not otherwise privileged, that I believe will help prove or disprove a fact or consequence, I'm entitled to obtain first from the other side, because most of the rules with respect to discovery are geared to parties only. Once the automatic disclosures have been made in accordance with Rule 26, which means tell the other side in federal court what the essential witnesses and documents and damages are in the case so that the other side can assess it and decide whether they want to talk, and the other side the defendant has to make the same type of disclosures and actually say what they think the case is worth. But once we get past those automatic disclosures in the federal court, then the question is, now that discovery can begin, where do we begin? A lot of times we begin with interrogatories. Interrogatories are written questions to the other side. Now, they are, well, first of all, they are the cheapest form of discovery, right? Because it doesn't require anything other than me writing up questions that the other side is going to have to answer under oath. Is it the most fruitful form of discovery? The answer is no. Because if I give you a question today and tell you you have 60 days to answer it, and you can talk to whoever you want, and then just write up the words precisely the way you and your counsel and all your friends say they should be done, well, I'm likely not going to get a very fruitful response. But it's going to be a response. Interrogatories, I think, are best used to fix parties' positions, right? Ask them the sort of the broad questions and some specifics about issues, so that don't expect a lot, but in that process, you can start to make them at least fixed as to what it is they're going to defend, what it is their position is. You know, what did you terminate them on April 1st, 2018? Yes or no? Or explain the circumstances under which the plaintiff was terminated on April 1st, 2018. Whatever it is, you have some story reduced to writing at that point. You shouldn't expect that it's going to be very damaging, but at least it's a story, because a lot of times as cases go and go forward and discovery takes place, parties and witnesses will change their stories to conform to what the evidence now looks like. So if I use interrogatories to sort of establish what that position you're taking is, as you move down the line and I get more information and I can prove you lied in those, or I can prove that that's not the story you told initially and now you're saying something else, that helps. Plus it costs next to nothing. So interrogatories are where we usually would start. But there's sometimes where you skip it, because even the last case we just had down in Connecticut, the answers were virtually useless. I knew they would be. But I mean, seriously, maybe the most useless ever. But even still, there were a couple that at the end of the day, as we got close to trial, there were a couple of those answers that I could use. And so nothing ventured, nothing gained. The cost is next to nothing. It's a good way to start. Sometimes, either after you get those responses or with those requests for interrogatories, you might send out requests for production of documents. Again, these are parties only. And what you're asking them for is to produce various pieces of information that they have in their possession, custody, or control. And they're obligated under Rule 34 either to produce them to you or make them available to you for copying and inspection. You know, at one point in time, we were worried about the cost of all the paper that had to be produced. These days, if you have a scanner, if they have a scanner, which they do too, it all can be produced on a thumb drive or even a DVD which can hold various forms of media and vast amounts of it, right? So still sometimes we get paper, and still sometimes we're looking for paper. And while they have an obligation under Rule 34 to make them available, you may have an obligation, and sometimes this comes into play with respect to proportional as well, that the cost to search it and the cost to produce it and the software to examine it become a factor as to what discovery you're actually getting. And that can all be, and oftentimes is fought about as well. You know, I think if it's straight, you know, an Outlook mail program and Word documents and the like, there's really no reason why we can't exchange thumb drives and have the great bulk of that information electronically. And the value to receiving it electronically, obviously, is now it's fully searchable and everything else. You know, when we used to get paper, and we still get paper from time to time, but when we get paper, then you've got the job of trying to get it into a database, trying to sort it, trying to make it manageable. And there are cases where if you've got a big business dispute, there are cases where you could have hundreds of thousands of pages, and the managing the discovery becomes a job unto itself. And so you got to think about that. What you ask for is what you're likely to get. And these days, I think some of this, the older problem is gone simply because most of the stuff isn't stored in this format anymore. It's stored in the soft copy format. Problem with that, on the other hand, on the other side is hit the button and it's all gone. So some cases where you're going to have to make a forensic examination of the equipment to make sure to see whether stuff has been lost to you in the process. In order to do that, though, you may have to take the next step, which is a deposition, right? So we've got our request for production out. We've got our answers to interrogatories. And by the way, answers to interrogatories, or your interrogatories, I would definitely ask what documents have been discarded or destroyed from the time, I pick a date or from the time litigation began. What is their document retention policy, things like that, to ask for, to sort of, again, pin them down as to what the story is before we get too far down and you find out, oh, yeah, we destroyed them all. So what is the ordinary policy and what might have been done here? You start to think about, well, what should I be looking at? The other thing about both those documents, interrogatories and request for production, if you're then withholding either documents or answers to interrogatories on the basis of privilege, then I'm entitled to a privilege log. I'm entitled to a document that shows me what you're withholding and on what basis, with some very brief description of the document, the sender, the recipient, the date, and the like. And so that way I can examine whether, at least initially, whether I think your claims of privilege are valid or whether you're trying to hide stuff. Almost always they're trying to hide stuff on a privilege log. Yep.
Now, what happens when you're this small lawyer going against this conglomerate and they give you all these documents and then they redact everything?
Yeah.
Because I've seen that happen. They give you boxes and boxes of documents. You open the box, redacted. You go to the bottom of the box, redacted. So what do you like? What's your
okay. Why are they redacting it? I want, and we've had this in the Connecticut case too. I want the privilege log. I want to know whether you're redacting it on the claim of privilege, and sometimes it's attorney-client privilege, and sometimes it's business confidentiality. Well, on what basis? If they're relevant to this piece of litigation, you don't have a right to withhold information that you claim now is somehow business confidential if it's not trade secrets and the like, right? There's some things that you have the right to try and protect. There's other things like what you're suggesting is they've just done it because that stuff is important. They did it to us as well. You now then are going to have to fight about getting that information and having them produce it unredacted. Because that is the other thing that is, again, more common today is, okay, you can have the document, but like you said, you pick up the piece of paper and there's 2 lines on the document. We had, the one we just finished was, the lawyers were intimately involved as the dispute was blowing up, and because they were giving them legal advice and trying to direct a course of action that they knew there was going to be a significant piece of litigation that flowed. And so there were internal company emails then that all of a sudden they're redacted. And they were specifically about this dispute on the hours, because emails, you see the minutes and hours, during the hours when this thing was blowing up sky high. And all of a sudden it's redacted. So now what I do, what you've got to do is I got to have a deposition of the parties, of the people who were involved in that, and try to narrow down what would have been in there that they possibly could think was redacted. Because, no one's in and set the foundation for actually going in to compel. None of the recipients, none of the senders here are attorneys, right? And so the answer is no in my case. And by the way, just because an attorney is involved in the sequence doesn't make it a privileged document. It's what a lot of companies do, though. I call it a privilege bath. They put an attorney on the email or an attorney in the room, and then their argument is that everything's privileged because there was an attorney tangentially involved. That's not the rule either. You're either seeking or in the course of obtaining legal advice, and the attorney has agreed to provide it. It's not straight business advice that a lot of these decisions are. That's not protected. It's legal advice. And the tendency is now that this is the route they take. What you have to do through the discovery process and likely depositions is establish enough in the record so that you're going to be able to show no claim of attorney-client privilege or any other privilege applies. The documents need to be produced, and then bring a motion to compel and ask the court to examine the privilege log and the testimony that shows this stuff isn't protected. But it takes a fair amount of work to be able to do it, because the court isn't going to lightly open up or even examine their privileged information without you somehow having some basis to show that this stuff isn't privileged at all. They tend to take attorneys at their words, but the problem with this is that they really shouldn't a lot of times, because there's a lot of attorneys who try to hide stuff under a purported claim of privilege that just isn't valid. What we did in the last case is, as we went to trial, we brought a motion in limine to order them to produce all of the redacted material, because there was all of it within the sequence of November, December, January of 2014 and 15, because there was no basis for the claim. At least we saw it as none. I know why they were saying it, because they were trying to prevent what they knew was a piece of litigation. But then, to me, you've got potential crime fraud, except you've got other problems with the attorney's involvement as well. But at any rate, in order to even get the court to examine your dispute about privilege, you've got to have enough information that the court is going to at least be able to think initially, well, this claim of privilege is likely dubious, because otherwise they won't even look at it.
Now, would you be able to, say if you found out that the company is using a third party as their cloud for their storage of this document, would you be able to circumvent the company and go to the third party?
It's still there. Well, you can, and I might try. Sometimes we do that with phone records and the like. They say, well, we won't give them to you. Well, I'll subpoena the provider to obtain them. If it's privileged, it doesn't necessarily matter whose hands it's in, but I might do it because it's a catch-22. I almost have to have a document. I have to have at least one of the string to be able to explode their claim of privilege. But how do I get it if they've built this wall of privilege? It actually is a big problem sometimes, to be able to have enough to tell the court, to be able to show the court that the privilege claim is bogus without having at least some clear evidence that the privilege claim is bogus. Like sometimes on the privilege log, they'll be claiming privilege for a document that doesn't involve a client, right? We've talked about that at the core. The person has to be seeking legal advice. The lawyer has to be agreeing to provide it. But what if it's a witness? Well, there's no privilege, attorney-client privilege. Maybe you got an argument on work product, but not a very good one, that somehow it covers non-clients. And so if I've got a couple of those in there, then I've got some basis to show that they're just filling it and not providing essential information. But to get past it is problematic. And what I've found is with the bigger firms and the more that's involved, oftentimes almost always there's stuff hidden on privilege logs, or attempted to be hidden on privilege logs, that has no basis to be there. To get the court to take the next step is not easy. But you would do it by way of a motion to compel, and have to argue that the privilege doesn't apply here at all. But it starts with, you got to make sure you get a privilege log, because a lot of people say, no, I'm not going to give you one. You can't claim it And there's always a blanket claim in the interrogatories and the request for production, and sometimes during depositions they'll claim it as well. You can't claim it and then say, but you don't get to see what I'm actually claiming it for. So you got to get the privilege log. And when you look at that, a lot of times you can start to see what exactly they're trying to hide from you. You can see the dates, you can see the names of the parties involved and all the rest. Okay, so we got our request for production of documents and things out. We talked about the format you can receive it, and that oftentimes is going to take months to get squared away and get your stuff. I then would go normally to depositions. I would wait till I have the documents. I favor a document-intensive deposition. I like to be able to start to put in foundation for certain documents, to be able to let the witness know that if they lie, I've got a document that shows otherwise. I think it tends to keep them a little more honest. Some people would start earlier on with depositions, but so then I've done my deposition and I find out later on that this document says that everything they told me was a lie. Well, okay, I guess I get it for trial, but I'd rather have them lie than make them eat the document and show that they lied and the truth is something other. So I like to follow the production of documents with depositions. Depositions can take months. Depositions oftentimes is a lot of fights about it, a lot of fights about what you can ask, and if the lawyers tend to be obstructionists, and some do, then it's going to be a miserable 8 or 10 hours. But that's the part of the job. We have the right to ask questions of any witness, by the way. Depositions are not just limited to parties only, they are anyone. And we have the right to try and gather the information that's going to help support our case and deny their defenses. Depositions are not cheap. You can easily be doing, $800 for a half a day's deposition, and a half a day doesn't get you that much. You pay for the stenographer, you pay for the transcript, and they are the most fruitful form of discovery because there's a back and forth. I can follow up on each question. I can look at you and determine whether I think you're being truthful or not. I can look at you and sometimes know I'm in an area that you're having difficulty answering, so I know that that's important. I can gauge for the purposes of trial whether this witness is going to help them or help me, and to what extent that I would think about calling them as a witness at trial. So depositions are the closest we get to presenting a witness at trial, except there's no judge there, so if there's any types of significant disputes about the validity of questions or privileges claimed or anything like that, we suspend and we go off to court. Oftentimes we're just going to keep moving forward and get it all done in whatever we have done at that point. Then if there are disputes about you refusing to let them answer certain questions, I'll bring them all up at one time on a motion to compel with the court. If I think your claims of privilege are specious, then I would do that as well. Sometimes you have to suspend a deposition because you think the other side is doing it for harassing or annoying purposes, and sometimes that's precisely what they're doing. And then we have to go to court and seek costs and the like. So depositions become vitally important, but also depends on whose hands they're in. I've had really nice ones with attorneys that get along and it's been productive, and I've had really miserable ones where we're just calling each other assholes by a lot nicer words.
Can you make objections at the deposition?
Yeah, let's talk about that, because that's important for you to understand from the practice standpoint. There's a couple things to think about just quickly. Depositions, okay? So I'm there with my client. If I'm taking the deposition, client has a right to be there, or the client's representative, right? So that they can assist you. They'll know the case a little better, but they're not really, they might give you a note here and there, but you don't want to be going back and forth with them at all, or not necessarily. The person who is being deposed will be there. Now, if they're a party, then the likelihood is they're represented by the lawyer from the other side, because they're the party. So there's two lawyers and two clients in the room. Sometimes they are the witness and not a party to the case, because anyone can be deposed. So my client would be there, the witness who I'm deposing would be there. They have the right to have their attorney, but that's up to them. Civil cases, no one's paying them to have an attorney. The other side would be there and represented by counsel, and the other side could be there. They're not always there. It depends on the witnesses and who it is you're deposing and how important they would be, okay? The deposition would start, the stenographer will swear them in, and sometimes the first thing, that says is the usual stipulations. And what that is supposed to mean, so that you understand, you should understand, okay, I'm going to tell you what that's supposed to mean, is that usual stipulations means objections except as to the form of the question are reserved until the time of trial. So and by the way, and I include, and this is why, I include privilege in that. You can't, if you answer questions with respect to privilege matter, you've waived it. So the usual objections, in Michael's view, includes objections as to form. No, all objections except as to form are reserved until the time of trial. And so what that means, if someone asks, well, what did Jeeves say to you? I could object because it's hearsay. But you want to ask it, go ahead. I'm going to exclude that at trial because it's hearsay. So objections except as to form are reserved until the time of trial. So what that means is form is the question is ambiguous or vague or not understandable, then it's an objection as to form. Because there's no sense getting an answer under those circumstances because the question doesn't make sense. So the rule is supposed to be, the usual stipulations is that objections except as to form are reserved until the time of trial. Now, I've said it a couple times. I know there's supposed to be, but there really isn't in a general understanding of what that is, I don't think. So when we say usual stipulations, and I say it too, understand it may not mean exactly what it says, and there are some lawyers that say, well, I don't know what the usual stipulations are here, why don't we go by what the rules are? And that's the important thing, right? Go back and look at the rules, because that's the key. The rules are what I described them to you. Objections except as to form are reserved until the time of trial, but you got to object as to privilege. So when we say usual stipulations, and you say, no, I don't think so, I really don't give a shit, right? Because that's the law anyway. They're just trying to be polite here, Okay, this is the way we're going to go. Okay, but that's the rule, right? So you don't make hearsay objections. You don't make any objections. They're reserved until the time of trial because there's nothing that says this is admissible at trial. It's still out-of-court statements, right? So it still has problems. At any rate, but what was your question, Ray?
No, I was just, you answered the question. I was really just asking, when can you, because I've seen before when lawyers in the deposition, they've objected, or they'll put that on the record. I object to that question. I think they do that so when they go back to the transcript, they remember, where they objected. Yeah, but see, it's really unnecessary because the rules say, and I would say that, or objection, and then you may answer. If it's not as to form, there's no, who are you objecting to? But you're right. Sometimes some lawyers will say, mark that, mark that, mark that, mark that. It doesn't need to be marked either, You just got to go find it. What's she marking? But people do that as well. Mark it, like, oh, you're going to pay for this. But by the way, depositions are where these cases are won and lost. And so you've got to protect your witness if they're being deposed, and you've got to be prepared to push for the evidence because without a judge present, there are some lawyers that are going to tell you this is what happens at a deposition and this is what you can and can't do. And you need to know what you can and can't do. We had ones, again, in this Connecticut, and he was really one of the biggest jerks I've ever litigated against. I've litigated against a lot of jerks. He was trying to argue, well, he wasn't arguing, he was objecting. He said, I couldn't ask the witness if his legal fees
were being paid by the defendant. Now, that's not privileged. That's not privilege, and it goes to bias. Clearly, I can ask that. And clearly, I already know the answer. But, your objection, that's privilege. You know it isn't privilege. That who pays your fees is not privilege. Neither is the amount, by the way. Neither is the fact that you're being paid by them to testify today, even though you're not an expert witness. But so you need to know what you can and can't get here, because there's a lot of pushing back and forth. And the only way I really learned that, all of that, well, some of it is practice, but I read those rules line by line by line and then said, so what does that mean? Because you got to know how far you can push. You got to know, well, what happens if the other person is a bully? I've had that, especially when we're younger and newer practicing. There are people that's going to try and take advantage of you. I have one guy down in Falmouth. He became a judge too. What a jerk! And he was just trying to intimidate my client from the get-go. It was a divorce. It was a good-sized one, but messy. And he was trying to just bully her and intimidate her. And I have none of that. But that's everything. He moves the flowers across the desk so he could stare. Just class A jerk. And I had to say, I said, a couple of times, I said, listen, if you go into this area one more time, and we are leaving the room. I said, they're going to suspend the deposition. I'm going to seek costs. I said, you've been leaning, and this is the other thing. Whatever goes on, you've got to make sure the record reflects it. You've been leaning over the table, pointing your finger at my client, raising your voice on numerous occasions. I've done that, right? Because they're only recording this. So if your tone is bad, and I will say that, don't use that tone again. Now, she's not going to say he said it in a loud voice, but she's going to, what my words will be, don't use that tone again. Your tone is inappropriate. If you're not going to be professional, we're not going to stay here. Before I'm ever walking out, I've got to make sure that there's enough self-serving evidence in the record that says that we were justified in concluding this deposition and not completing it. And that's the other thing to think about. Okay, if they're being a bully, how loud his or her voice isn't going to show. Their body language and their gestures isn't necessarily going to show. You got to make sure that the record reflects that, especially if we're thinking about getting up and walking out here, because that's not something you do. And by the way, you can threaten to do it as not you, because you get a little off the rails yourself over there. But you can threaten to do it with not do it, right? I mean, and it's not something you should do lightly, because now someone's going to get costs. Either I'm getting costs because you were wrong, or you're getting costs because I was wrong. And no one needs that. So it's a means of keeping it all on the rails. But depositions, you guys got to look at very carefully, because, again, there's other things to think about. Some jurisdictions limit the number of depositions you can have and limit the amount of hours you can take in a deposition. So that's the other thing some lawyers do, is they try to drag it out. I had one scheduled here. He shows up 2 hours late. Then he says, well, you said we'd be done by 3. Yeah, I said we'd be done by 3 if you were here at 9 a.m. in the morning. You didn't show up till 11 o'clock. It's not going to be done by 3 now. And that was absolutely deliberate, so that I could have less time deposing his client. So it's where a lot of the battles are engaged, especially with lawyers who want to abuse the process. And you've got to be careful that you don't become a victim to that. Because at the end of the day, your client is expecting to win. The other common tactic that some cheaters use is they'll finally produce the box of information on the day of the deposition. So they come in and they get there at 9, and the first thing they do is they give you a banker's box. Oh, we found a bunch of stuff that you had asked for. Now, I can't ask questions and look at the box of documents, and you damn well know that. That's why it was produced today. I'm not going to refuse that box, and I'm not even going to talk about it just now, because I want to get 4 hours worth of work done. But at some point before today's done, we're going to talk about you produced a banker's box of documents at 9 a.m. this morning that should have been produced 2 months ago. And I'm likely going to then, I will look at those at lunch. but I'm gonna have to look at them very quickly. But what I'm likely gonna have to do then, instead of concluding that deposition, is suspend it. And I'm gonna suspend it because I haven't looked at that. And what I know for a God's certainty is there's important stuff in that box. It's not the first box you get that's important, it's the last one. And I know the reason you held on to that is you didn't want me to have the time to be able to work with it. So I'm gonna go through it at lunchtime and really pull out some of the most important. But I'm also, when I do go into that information, I'm gonna say, I'm gonna try and get done as best I can today, but because that box of documents of, the banker's box of 4,000 plus pages was produced at 9 a.m. this morning, the likelihood of finishing today is impossible at this point. So we'll move forward as best we can, and then whatever time we're done, I'm probably going to suspend the deposition. We're going to have another fight, but I'm going to suspend it instead of concluding, because I'm not agreeing that you're released at this point. You may well come back, depending on what I see with this document, what I see with the documents, and in fairness, in honesty, what I get from other witnesses, because now I legitimately have a reason to bring you back after some of the others are done.
So, sir, can a party refuse to be deposed?
No, I mean, you can refuse, but you're gonna get sanctioned. Not a party, right? Party, you don't have the ability. Parties, and that's why all the rules for discovery allow parties to have to engage in discovery. Because they are parties, they are agreeing in part to cooperate with discovery. Legitimate discovery. You're going to have to be deposed. You don't necessarily have to be deposed about your, if it's a business dispute, your ex-wife's crazy claims of whatever it is, except maybe they're relevant, I don't know. But you don't agree to be abused in the process, but you're going to have to be deposed, especially a party. Witnesses even, because witnesses say, well, I'm a stranger to this and all. Why do I have to come in? Well, because you were served a subpoena, and we think you have information that's important to this case. So even non-parties don't always want to be deposed, but they have an obligation to if they're under subpoena.
If you receive that box that's late of
Yep.
these documents, do you read it into the evidence or read it into the deposition of that first case that we've received this box of documents, has 4,000 documents? Do you put that into the record?
Yeah, but I could do it right away, but that's just going to set us off. That's going to start a fight at 9 a.m. I'm going to fight, but no, I'm going to fight. And it's a question of whether I want to do it now and sort of, do I want to punch you in the face first thing in the morning or after lunch? No, really, because we're going to fight. You, by the way, you set it up so that we're going to fight. You think you're just going to walk away? But if I say, I can do it. It depends. It really does depend on what result I want to get. Because if I want to provoke back, I'm going to say, you just produced a box. I want the record to clearly reflect you produced a banker's box full of documents that should have been produced to us 2 months ago. They obviously would appear to be important to this deposition. We'll do the best we can to conclude today, but I'm telling you right now, we may not conclude today because of your late production of that information that you knew was clearly relevant. Now, if someone makes it, that's obviously going to provoke a response from someone. So maybe that's not the best time to do it later, and try to get some information first, see where we go. By the way, one of the things I'm gonna ask about, so I'm gonna do it just a little more. So, when did you got the request for production of documents? What did you do in reviewing that request for production of documents? I'm going to ask the witness. If they're assuming that the witness, obviously they should be related to the witness, or they're likely. So when did this all take place? So I'm going to lay in the foundation that the lawyers likely had those documents for months, and so it's even less reason why you should have turned them over this morning. And and by the way, it's always a good place to me to start to make sure that whoever was supposed to be looking for documents and answering the interrogatories, that they actually were consulted and did these things. Because if they haven't, then that's important to know that, well, then who the hell was charged with looking for documents and obtaining this? How do I know there's been a good search for the stuff I was looking for that you were supposed to turn over? So I'd do that anyway. Okay? So, We've done that with the usual stipulations, we'll call it, but it's what the law allows. And then if we want to use those depositions later, then we still don't use the entirety of the deposition. You can only use those portions that are admissible, okay? And that's a trial issue for another day. Let's suppose, so request for admissions. Requests for admissions happen relatively shortly before the conclusion of discovery. And what they are simply are statements of fact that the defendant is or the other side is required to simply either admit or deny. The whole idea behind them is to simplify the issues that need to be actually tried, that evidence has to be received on at trial. So to the extent that you admit things under the admissions of facts, no longer need to offer any proof on that issue at trial. The fact is conceded. To the event you dispute it, then I've got to provide evidence of it, of that matter. The example I always use is, let's suppose we've got a dispute about the value of this building. So I give you an admission of facts that say, the building at 500 Federal Street is worth $15 million. And you say, deny. That's an admission of facts. You admit or deny. You don't get to explain like an interrogatory. So you deny. If I then have to introduce proof on that at trial, which means I've got to get an appraiser, I've got to pay the appraiser, and that could be $5,000 before we're done if that appraiser has to show up at trial and testify. If the court finds that you could have and should have reasonably admitted that the value was $15 million, then the court can charge you, the other side, with the cost of that expert witness. And so admissions of facts do allow some issues to be more easily established if they're admitted. And in the alternative, if those items then prolong the court case such that you have to offer proof on them and there's a cost attached to that, the court can assess the other side for costs of that. Yep.
So do all these come before the filing of a complaint?
Nope, none of these come before the complaint, right? The complaint is filed. There might be some early, and then it's served. With the summons, it's served on the defendant. Defendant can file a motion to dismiss, or motions to dismiss, or an answer. If the motions to dismiss are resolved and we're still moving forward, then they file an answer and any counterclaims. Then you have the voluntary disclosures. You might have a pretrial conference, right, an early pretrial conference under Rule 16. Oftentimes in federal court you will, so that they establish the time deadlines and when we're going to be able to move forward and what the issues are. And then the voluntary disclosures in place, then we open up the whole process of discovery.
Okay, but you know how sometimes always in the answer you admit or deny certain facts. So why didn't you come back again to?
Well, because in the complaint, all I have to do is establish a prima facie case that a wrong has been done and there's a legal injury for it. And so all I'm doing under the notice pleading system is put the other side on notice as to what the claims are about. Admissions to sufficient facts are much more detailed than what might be the allegations in the complaint, like the value of the building. I might not even have put that in the complaint because it wasn't necessary. Now it's an issue that has come up that we need to establish at trial. Now it's got to be done. And by the way, the other side of that, what I find is that oftentimes it's very easy for the defendant to simply deny everything in the complaint. Now again, it's not the way it's supposed to be, because consistent with Rule 11, they're supposed to plead only in good faith. But I'd be cynical, I guess, if I said that the court tends to give a pass to the defendant and very carefully hold the plaintiff to that standard. But in my experience, it's true. More often than not, the defendant denies virtually everything when they're not supposed to. They're supposed to admit what it is, what they know is true. I think in part that is done because we oftentimes plead our complaints poorly. I think each you know, for trial, we say one fact, one question. Don't put a bunch of them in there, because then the answer gets lost, and it's just not one fact, one question. And I think the same thing stands true for the complaint. You know, don't put shouldn't be a whole bunch of sentences there. There should be one, and then they've got to either admit it or deny it. You know, the plaintiff was hired on such and such a date. Admit or deny. You know, or plaintiff, maybe hired is the wrong word. Plaintiff started work at whatever the name is on such and such a date. And that's the thing to think about when you're drafting the complaint, is it should help to narrow the issues. But part of it is then you've got to, there's an unlimited number of numbers in the world. You need to be very precise in your wording and very short in each. I think it's almost one sentence, one number, and they have to admit or deny. Because I think we play into that by putting, you know, half a dozen sentences in each allegation in the complaint, each paragraph number, and then they can say denied, because they can deny a portion. Again, they're not supposed to, but it gives them more cover. I think we can do a better job with that. Go ahead.
Oh, sorry.
No, this is important.
Depositions by written question.
Yeah.
Now, I don't see the value of it when you're talking about a party. Now, a witness.
Yeah, right. There isn't.
Okay. I just don't see it. It's like, I feel like it's arbitrary.
Yeah, right.
Well,
They value a deposition upon written questions. It has some value to a non-party because you can't send them interrogatories. But to a party, I think interrogatories are fine. You know, the thing is, though, let's suppose I'm suing ABC Corp., but Ray's the driver for the bus that was involved in the accident. Maybe I need to send depositions upon written questions to Ray, because I can send depositions upon, I can do a deposition or interrogatories with ABC Bus, but with Ray, I'm not going to be able to send him interrogatories even though he's an agent of the party. So that may be, again, I mean, in that case, that context, I could see them valuable, and again, they're inexpensive. Because that's the other thing is, this, as we sit here, it sounds kind of easy. Let's do a bunch of depositions, and it's not heavy lifting, and it actually, I enjoy it. I like the hunt. When we're talking $1,000 a pop, and then having to do all the work and prep for it, and then to debrief from it, it's not an inexpensive process. And especially now, the courts tend to limit some of your ability to just go on your extensive hunt. So you have to be a little more selective. And the other part of that is just realistic, right? How many of our clients have another 10 grand? And that's what we're talking about for even the relatively modest case between production and depositions, and then potentially, you know, geez, 10's probably not even going to cover an expert if we need an expert of any sort. So the costs get expensive. If you don't comply with discovery, if I don't think you're being fully forthcoming, I'm going to bring a motion to compel production of the information under Rule 37, right? And there the court has the power to sanction the other side for their disobedience in not producing the information sought, whether they're answers to interrogatories, whether they're documents that should have been produced under Rule 34, or whether they are depositions that you were not forthcoming about or impeded improperly. The court has the power under Rule 37 to sanction the non-complying party or to compel production. And that's really oftentimes what I want. But in the event you won't provide the information, then I want you sanctioned. That sanction can be costs. That sanction can be precluding you from trying certain issues in the case. And in extreme cases, that sanction can be that you have lost the case because of your disobedience with the legitimate court request, with the request of the other side through discovery. So Rule 37 gives teeth to the process that this should be a cooperative endeavor. Unfortunately, it's really, in many, many cases, it's not cooperative at all. It's push, push, push. And it's what makes a lot of people wary of the expense and time and hassle of civil litigation, because it consumes by far the bulk of the time a case takes from the time it's filed to trial. You know, if months 1 through 3 or 4 deal with motions to dismiss and answers and counterclaims, really months 4 through 14 likely deal with discovery, and then ultimately the end of that, summary judgment. It's the bulk of the time is spent in all these little skirmishes back and forth. And it should be easier, but parties oftentimes withhold information because they know it's harmful, or they feel that they have a claim of privilege, but I don't think that's oftentimes is the case. We gotta come back to our surrogacy contracts. And so your assignment last time was how far are you gonna go with respect to provisions in your surrogacy contract, because we read Johnson versus Calvert, which talked about the procreative conduct that the people who gave birth to the idea of giving birth to a child are in fact the parents, but we still may need someone to either provide the egg in the womb, or the separate people to provide the egg in the womb, or someone to provide a place where that child can develop over the period of the next 9 months and the like. So I need you to remember, we started from the proposition that you can't specifically enforce a personal service contract. So that's where I want to jump off from. So what does that mean regardless of what provisions we put in here? Because some of these provisions are kind of onerous.
You can't force somebody to have a baby.
So they can have my wife's egg and my sperm and then decide somewhere down the road that they're going to terminate my child.
It's kind of that specific performance.
Well, but these aren't, I mean, we do specific performance for unique goods. A child isn't sufficiently unique that the court should protect it when we have an agreement that you would? And so you're saying I can't, and if that life is unsatisfactory, we've determined that through genetic testing, I can't force the surrogate to have an abortion? By the way, one of these, I grabbed a couple checklists, surrogacy contracts. One of them puts it this way, because you gotta think about this too. I didn't think about it until I saw, I mean, I've thought of it before, but until I saw it the way they read it. Difficult caveats, because they talk about how many embryos per attempt. That all has to be spelled out. What's the time frame, right? It says here, time frame, no more than 2 years after signing the contract, or number of attempts, at least 2 transfers. So you've got to, I mean, doesn't always take the first time. So you've got to agree, the surrogate is agreeing to be bound to whatever it is you're asking them to do for some period of time. And if you're going to implant the egg or the embryo into the surrogate, so if it's 2 years, does that mean the surrogate can't have sexual relations with their partner for 2 years?
Yeah, depends.
Well, I think you can't, sexual, it's like a natural right for everyone, so I don't think you could. You could probably say, you know, the
Well, then how am I sure it's my child as opposed to the surrogate's? I mean, doesn't that sound, I mean, and I understand what you're, right? I mean, that's why these are difficult questions. But at any rate, okay, so, because it talks about time frame 2 years, I want to get to this point. Difficult caveats. And how many embryos are going to be implanted at once? They refer to it as selective reduction in the case of multiples. So an agreement, within the agreement, that we don't want any more than 2. So if you've got 4, we agree, we're gonna abort 2 of them. Or as we say, selective reduction. No, right, that's what, I said, oh, that's a clever way of saying it. But what about that? So you're gonna contract that right? And by the way, if you can contract your ability to waive your Fifth Amendment and say, I killed Jeeves, and go to jail for the rest of your life, why can't you contract this right away, these rights away? And then, okay, so then the other things you need to think about, it says here, what about severe handicap in the child? Right? Because here's the problem. Okay, so we want to abort. That was our agreement. You say, no, I can't do this. I can't. The child is now moved inside me. My world is different. I can't. So your child then? My financial support or not? A severely handicapped child is going to consume a vast amount of resources. So, and if it's not the people who had the procreative conduct, surrogate, we've already said, probably is not in the same financial position, well, then it's the state. That's us again. No?
Isn't it illegal to actually, because we're going upon a woman's choice, right? So to contract against the woman's choice, or to contract to pretty much bar her from making the choice, wouldn't that be against public policy?
I'm asking you. And by the way, even if it's not, how do we align this with the cases we read, which said you can't enforce a personal service contract anyway. We can't get someone to paint your house or your picture. We can't make Warner Wolf work for ABC when he doesn't want to. And now we're going to tell someone how they're going to live their life for the next 9 months, and not just tell them you got to work for ABC. We're going to say, and no drugs, and no alcohol, no smoking, no sex, no, and by the way, if we want you to have an abortion or selective reduction, you will do it. No? I mean, go ahead.
Maybe they've waived their rights.
Look, you
by
can
signing-
waive you can waive any right, can't you?
Right.
So even this one?
Signing this contract, they've waived a numerous amount of rights. I mean, pretty much.
And
all rights.
will the court enforce it though? Or is this still the classic? I mean, this is a personal services, right? I mean, it doesn't get more personal than these services.
Right.
And so it's a personal services contract. What happens if, and you know, the whole Baby M case, there's other cases that this is where the problems came from, is that surrogates change their mind, especially when the surrogates have a biological relationship to the child. They are not just the womb for rent, but they provided the egg. Problem, I mean, you know, there's more problems, and it was harder in the Baby M. They still said, no, you agreed that this is what you would do. You're bound by that conduct. But we don't have anyone in the middle here that we have, which is saying, no, listen, I'm not going to take those vitamins. I'm not going to go to the doctors regularly. I'm going to smoke. And we know that some of that stuff is really bad. And so it even says caffeine limitations, which I think that's true, right? My daughter-in-law just had a baby. But so not just alcohol, I can't have, I mean, right? I can't have coffee, I can't have a Coke, right?
Well, I think the requirements around, like the requirements around the pregnancy, I think those are all like okay to an extent, because a woman has to do that. A caring mother-to-be would have to do that anyway. But I
have to or should, Ray?
Well, should, I should say should. But my biggest issue is the option of choice, and I think that's going against public policy now. We're pretty much telling a woman that, look, you signed this contract, you pretty much don't own your body for the next.
But it's not just your body, isn't it? Mine and my spouse's too.
Yeah, but my thing about that is that without the womb for rent, those embryos is pointless at that point. They're moot, so to speak.
But at some point they're not, aren't they? I mean, at some point that is a living, breathing person. So wait a minute though. So I don't have any say, even though we agreed in advance because we were concerned about some of these things. and if you look at the checklist, this one, are there religious preferences for either the surrogate or the intended parents? What does that mean? Does it mean, are you telling the surrogate that she has to attend certain services, or are you just saying this is one of these, here's my checklist, I want, 1,400 on the SAT, 6 foot tall, and whatever the religious preference is?
I think they would probably say that there is a religious conflict with the surrogate, saying that since they gave birth to the baby, now they feel like that's their child. You know what I mean? Maybe there's some kind of religious clause, some kind of religion that makes them feel like that baby is theirs.
Yeah, I didn't get the impression. I got the impression sort of that, along another one of these checklists for the master race type of thing.
That's how I see it, honestly. That's how I really, I see it. Because I've actually looked at these things myself, and I'm like, hold on, and the requirements are very, stringent. I don't know, my biggest problem around the whole situation is taking the woman's right of choice away.
And I hear you, and that's why I wanted for you to think a little bit about it, because obviously that's an issue. If we're 4 months in, and I'm thinking this is our child, this is finally, we're going to be able to accomplish this, and the surrogate has a change of mind, even, and I'm putting away the monetary aspects of it, because the money becomes irrelevant in these disputes.
Then what happens if the surrogate skips town?
Yeah. No, I know.
What happens in that situation?
Well, okay, so that's the ultimate question. What if they're not doing this? Could we get an order from the court to have someone monitor them to make sure they are complying? Could we have someone sit with them? Could we jail them?
Wow.
I'm going to leave you on the wild.
No.
Huh?
You jelly my baby? No, it's not gonna be.
No, but listen, there was a case down in Fall River. It's completely different. The older child had died, some type of religious sect down there, and she was very pregnant again. And they actually, they didn't say it was for these purposes, but they jailed her for the last 3 months of her pregnancy, on some criminal charge because of the concern that she would harm the baby, or the baby would be born and then they would kill the baby. So you're going to jail these surrogates who don't comply?
And then the other side of the pie too is that when you think about it, kind of like you said, you're creating this elitist master race. So now, what about those women or those indigent individuals that actually can't give birth, but they want to do this too? So what are we going to do? What the government's going to do? Step in and say, okay, we have grant money that you can do.
I don't know. On those points, we will finish.